Thank you.
Okay.
Go ahead, Mr. Ba.
Okay, your question is that you want to know whether there is any law that that allows foreign ISPs to...
No, I mean, do we have any law that limit the number of points of presence of foreign ISPs in our country?
I would have to say I have no idea about that, to be honest.
I think, I don't know if the regulator or MOICI can comment on that. They would probably be more in a position to. If not, we'll have to take this offline. Moda Aliu?
Yes, ISPs, there's no discrimination whether Gambian or foreign, and their points of presence is left to them. Wherever they want to serve the people in the country, they can serve. Right?
Thank you. I think Pura would also want to weigh in on that. Max?
Sorry, just to clarify quickly, the act that established Pura and the IC Act do categorically say that every player in the ICT sector in Gambia, especially service providers, have to be licensed. And if you are a foreign ICT service provider, you need to actually have a registered company in the Gambia licensed to provide these services. So you can't have even one presence in the Gambia providing any service if you are foreign. Thank you.
Okay, thank you.
Thank you. We have one more intervention, and that's it. And you have exactly 1 minute. Please state your name and the institution that you're from.
Okay, good afternoon once again. My name is Abdul Karim Sane, doing CCNA at MDI. From my CCNA class, I'm made to understand that as a network administrator, you can restrict people, like for instance, using access control list. But then the access control list that you can use can be a standard one or an extended one. And when it comes to extended, you can restrict people to servers that are even outside just by using their IP address. So my question is, I believe we all don't want our families to be users of pornographic content. So what policies and plans do we have for ISPs to be, or be it national or regional, in filtering or blocking pornographic content that pass through their network traffic? The second question...
Sorry, I can only take one question. Your time is up. I'm sorry. If I don't do this, we will never ever get to the next session. And the gentleman behind you, I urge you to send your question to the email list, info@gmigf.gm, and we will get the panelists to get back to you. Thank you for your question. I believe to sum it up, you want to know whether there is a policy in place for ISPs to filter traffic when it comes to pornographic images. We have a handful of ISPs here, but I think that question should be for the regulator. No? Pons would want to weigh in on that.
I think it is very obvious the regulator doesn't regulate content. And once you start going into content, you start infringing on people's rights. You can regulate the content at your home, what you want to watch. You can regulate the content you want to watch. But once you start going into the issue of regulating content, you are now infringing on the basic rights of any individual. People like CD, who works with tablets with schools, and also is an ISP, will tell you that schools have firewalls to protect what content should be seen. You know, so I think we should be very clear about that, that we can't start talking about regulation of content. Thank you.
Thank you very much, Pons. And it seems the gentleman is still there. Are you happy with your response?
I'm not very happy. I'm not happy. Because I believe ISPs can do something when it comes to content filtering or blocking.
Okay,
so
hold on.
When it comes to pornographic content, I believe we should definitely do something with it, because our society is being spoiled, or is being, you know.
Sir, I can see you're very passionate about this topic.
Yes, because I've witnessed.
Okay, yes. I could, so, I want to help you here, right? Basically, what we are saying is this, right? That you are very passionate and you have a point of view, right? But that is your point of view. Okay. And what the lawyer said, what the lawyers had said earlier, what Bart has said earlier was that if you look at the constitutions, right, your right is guaranteed as long as it does not infringe on the right of the next guy. You understand? That yes, you have a right. All your rights are your rights. Right? Okay. But no, listen. Let's not, you know, when we're having a dialogue, we have to be realistic, right? Okay. Because, I mean, the new Gambia is a democracy, right? And in a democracy, all of us in this room have to agree, right? You understand? And that's what makes a democracy hard. As much as you can fundamentally have a very strong view about something, it is your right, right? But you have to be able to convince everybody in this room to go along with you, right? And yes, while you may say that, look, I believe that we should ban pornography completely, 100%, right? There are others in this room that will be silent and will say, hey, for what?
Okay,
huh? But no, hang on.
No. He has a point.
The point, and again, it's your point, it is your right. But your right cannot infringe on the right of the next guy. Yes. All right? Make sense? All right, so therefore, if we break down your request, you are saying that you don't want to see pornography anywhere. If you call the ISP will make sure that the internet coming to you does not have pornography. That is your right, right? But you cannot, and this is the beauty of a democracy, because remember, this is what Yahya Jammeh was doing, and this is why we all went to vote. He will come up and say, I don't want, it has to apply to everybody. And we all disagreed, and we all went to vote him out, right? And when he said he wouldn't go, we all said Gambia has decided. Right? So therefore, Gambia has decided that right, we should respect each other's rights. That you have a personal view, I agree, but it is your view. You have the right to filter pornography, talk to the ISP, but you do not have the right to say that the ISP should filter the internet of everybody, every other Gambian. That is Yahya Jammeh. That is the old Gambia, and Gambia has decided.
Okay, thank you.
I think, let's agree. I think that answer, that should be a fair response. Huh? Yeah. But if you want, we can talk about it outside. But
then I'll still appeal.
Okay. Thank you, sir.
I'll still appeal they consider the younger generation too.
Yes. So with the younger generation, that is the right of the parent.
Yes.
I am a father. I have my right, until my son is 18, right? He is my responsibility. It is, I have the right to control what he has access, right? But that is my right, understand? So you cannot come and tell me that you should block this for your children, right? Remember, that is old Gambia, right? In New Gambia, your right stops with you and yours. Okay. My right is me and mine. Okay. And we need to respect that. What we can do is that we can agree on general principles, such as the Constitution, that govern. But the fundamental thing of the Constitution that allows us to live next to each other as neighbors is that I am guaranteed all my rights as long as it does not infringe on your rights. All right? Okay. That is very important.
Thank you.
Right? Thank you.
I think on that's a great note to close off on. We're going to have our next session with our speakers. If I can just have them to come up, and we have the facilitator as Omar Sambo. The discussion will be on intellectual property. So today is definitely lawyer day or legal day. We have lots of lawyers here, data protection, privacy, intellectual property. Very interesting discussion. So if we can have Penda Jibril up here from ADRS, Rodin Renner from Pura. Is he here with us? Max. Oh, he's here, he's outside. We have a representative from the National Council for Arts and Culture. I believe the name is, I'm sorry, Mr. Sheikh? That's correct. We have a representative from National Council for Arts and Culture. We also have a representative from AG's Chambers. I believe it's Mr. Aliu Jallo, who will be one of the panelists, and the AG's chambers will also be facilitating this session in the person of Mr. Omar Sambu, and he will be helped or rapporteured by Ms. Abby Foy. I'd just like to thank the panelists that just left. I think that was a very engaged session. I'd like to thank them all for coming on board and entertaining all these questions and interventions. And I'd like to thank my able rapporteur, who is the program officer for the National Youth Council, Mr. Kausu Silla, that just left the stage. And he's also the executive secretary for Africa Youth Council. So Kausu, thank you very much for helping me on board. And I will pass the mic over to Mr. Sambu, who will be facilitating this session. Lots of lawyers on here.
Okay, thank you very much, Ms. Gillen. We are grateful to have this session. Right? It's like one of the panelists is not here from Puro. So maybe we can have a Pura volunteer. That was Mr. Max. Max, are you coming? Okay, in his absence. Oh. Okay, so in her absence, you will still continue. So before we start, I would just like to give you a brief synopsis of what intellectual property is. But before I do that, I will introduce the panelists. Starting from myself, I am Omar Sambu. I'm a lawyer, and I work at the AG Chambers. So at my immediate right, left, I have Mr. Sheikh Omar Jallo. He's the Director of Visual and Fine Arts from National Council for Arts and Culture. Okay, after Sheikh Omar, you have Mr. Ali Jallo, who is also a senior lawyer, and is currently the acting Registrar General at the Industrial Property Department of the Ministry of Justice. Just at the far left, we have our only lady panelist, who is Penda. She has been very active in terms of intellectual property, and she works at the Alternative Dispute Resolution Secretariat. Okay, so this is what I would like you to have at the back of your mind before we start this session. How would you imagine life without technology? For instance, would you imagine living without a smartphone, without a laptop, without Facebook, without WhatsApp? Can somebody answer that for me before we continue? Okay, I know we wouldn't want to live without those things, right? So what intellectual property does is, generally, is to encourage and provide incentives for persons who create laptops, like Apple, for persons who venture into creating apps that we currently use to enhance our living. I was very glad when I heard Mr. Bensouda ask the participants what internet or technology does for people. So, in the absence of intellectual property, all of these innovations or all of these inventions wouldn't have been. Currently, if you look at the value of Facebook, for instance, in terms of branding only, Facebook is valued at $94.8 billion US. All right? And when you look at Apple, Apple is valued at $182.8 billion US. Facebook is just an application, as we all know. It's not a physical property. So intellectual property covers the property that is not in physical forms, like Facebook and other things. So my panelists will discuss to you the various components of intellectual property, which includes trademark, copyright, trade secret, industrial design, patent, and utility model, as it relates to internet and internet usage. So I will first start by let's start with the lady, right? With Ms. Penda to commence the presentation, please.
Okay, ladies first then. Thank you. I know this is the Internet Governance Forum, but when it comes to intellectual property, it covers a whole lot of things. It's just not technological innovations. We have music, content, which is covered as well as patents and designs, which can be technological designs or industrial designs. So basically, I think what we need to focus on is how do we encourage people to develop their intellectual property? Because intellectual property is a personal ownership. It's what's in your head that you translate to paper so you can share or sell it. So intellectual property translates to money. And obviously, if you're going to invest your time and research and development into a product or into writing a song, you want to guarantee that it is protected. And no one else is going to benefit without your consent to using this or making money from your hard work and sweat. So that's what intellectual property is, and it covers a whole lot of areas. So there's so many aspects of it, so I'll just touch on it. We have experts in particular areas. We have issues such as monitoring, because obviously if you are going to develop a song or a product, you want to know that it is not being violated and abused. And I know we've all done it, where we download things that we don't pay for. That is actually infringement of an individual's intellectual property, because by right we should pay for whatever they have developed. So there have to be ways where this can be monitored so people's rights can be protected. I would have liked someone from the Collecting Society to be here to explain how that helps artists and movie producers and musicians protect their intellectual property. The role of the Collecting Society basically is to get radio stations to pay for content that is being used by artists that are registered with them, nightclubs, so that the artists themselves don't have to go out and ask everyone to pay for using their music, but the society collects on their behalf and then they distribute it to the artists. The other way of monitoring is for the individual to monitor, which is difficult, but then you probably have heard of cases that we've had here where people's books have been exploited and have been reprinted word for word en masse and distributed to schools or being sold, so somebody else is using your intellectual property to make gain. We had cases that have been to court here on that, and the intellectual property of the author has been protected. It's very important that we have strong enforcement mechanisms, because that encourages people to be more creative. You're more comfortable to say, if I spend time developing a product that in the instance that someone infringes my rights, I will be compensated. So that discourages people from abusing your rights, but it also encourages people to be more innovative and to be more open and to spend more time developing things. We live in a country where agriculture is, I think, responsible for 70% of our GDP. Should we have strong intellectual property rights, we should encourage people to do more research and development within the agricultural sector so they can develop better equipment or maybe better pesticides so they can protect their crops. In other countries, research and development is carried out by universities, and this is how a lot of universities make their money, from their R&D departments. We have a university here that has a school of agriculture. We have a school of medicine. We know we have a malaria problem. We should start looking into those areas. When R&D is carried out under schools and universities, the intellectual property belongs to that institution. It doesn't belong to the individuals. But they put money into it and they can make money. That's why you'll see in the Western world, big pharmaceutical companies, they have huge research and development sections, but they make a lot of money from it. So basically, protecting someone's intellectual property rights helps with R&D and makes people more innovative. It also encourages people from outside to bring in their products and goods into the country because they know, should they bring in maybe, I don't know, a car with a specific design that does something absolutely fantastic, if they bring it here, people won't copy it, and if it is copied, they can go to court and their rights will be protected. So that's another good reason why we should have strong intellectual property laws and enforcement. However, it's also two-pronged because if the regulation is too strong, then it also discourages people. So it's a fine line between what is too much and what is just enough. The other issue, which I'm sure Mr. Jallo will touch on, is registering your trademarks, copyrights, and intellectual property patents. I don't know if we have registered patents, Gambian-made patents here, but there's a process which you have to go through to register with the Registrar General's office. But when it comes to registration of your trademarks, the process and the costs also affects people registering their IP, because if it's too expensive, you get discouraged. If it's a very long process, people get discouraged as well. So I'd like to stop there for now.
Okay, thank you very much, Ms. Pender. I'm glad that you talk about the incentive to create. What incentive to create simply means, to dwell on her statement, is to encourage people to venture and continue to innovate and develop products that they have already invented or innovated, so that they are able to generate that which they have spent or even more profit. You will agree with me, or even business-minded people will do, that nobody will invest into a business venture when you show that you are not getting any way out. So that is what IP usually sometimes also protect and assure. So without much ado, I will pass the mic on to Senior Counsel, Mr. Jallo, to continue.
Thanks, Omar. Thanks, Penda, and good afternoon to everyone. I would like to start by saying IP rights are generally private rights, and the reason why we want to secure our rights is also because we want to enjoy a monopoly over, our invention. So whatever it is that we seek to protect. In that regard, there is a procedure that an applicant has to go through. You either go through a national route, a regional route, or an international route. And to be specific, in the case of the Gambia, if you want to register your rights, it means there are two places where you can have your rights registered. And that also brings to mind the need for us to understand that in terms of intellectual property, it is a two-pronged subject area. We have the industrial property aspect, as well as the copyright and related rights, or copyright and neighboring rights, or ancillary rights. And my brother from the National Council for Arts and Culture maybe will take us through the copyright bit. But just to clear our minds, for us to understand what is it that we are talking about, IP deals with two things: industrial property, copyright and related rights. And there are two laws to that effect. In the case of the Gambia, we have the Industrial Property Act, which deals with industrial property, and it is under the purview of the Ministry of Justice. And then the Copyright Act number 10 of 2004, which is administered, of course, by the National Council for Arts and Culture. So, in case of industrial property, registration secures the rights. If you have industrial property, say it's a patent, utility model, a trademark, industrial design, and what have you, what you need to do is to register your right. You will have it, but the registration secures your right. So in case of a patent, it means that we have to look at certain patentability requirements. It's not just automatic that you have come up with an invention and you can have protection for your invention. It goes through an examination process, and the technicians or the experts in that field will have to examine your invention and to establish the fact that the invention is coming from you, meaning that it is new. Generally, it is not anticipated by the prior art, which means that any information relating to that invention must not have been in public domain before you came up with that invention. So it means that if, say, a student from University of the Gambia or a student from the Gambia Technical Training Institute develops a device for which he seeks, or he or she, I want to be gender sensitive, seeks protection, it means that you will have to make an application to the relevant office, in this case, to the Industrial Property Office at the Ministry of Justice, explaining what constitutes that invention for the purposes of registration of that particular invention. So that invention, I'll try to be brief because we don't have time. That invention has to go through an examination procedure to establish the novelty, to establish that it is also coming from you. Because that is why I said it must not have been anticipated by prior art, because it means somebody must have done a presentation in that regard somewhere, then that invention wouldn't be new. So when we process your application, it will have to go to another office, let's say our regional office, where the experts who are the examining authorities there will have to go through your invention after you have provided all the information regarding that, and then to recommend for protection as a patent or protection as a utility model. Virtually, the law for utility model is the law for patents, but the fact is that the duration of protection for a patent is more than that of a utility model. So in that sense, it means that you have to satisfy what I have earlier mentioned, registration requirements before you can have registration. The fact is that you need monopoly over that invention, and the law provides that you can have monopoly over the invention provided you meet the registration requirements for a period of 20 years. Now, what it means also is that you will have to do a disclosure. There is a disclosure agreement between you and the authority giving you protection. And the only authority that can give you protection is the government, or a regional body, or an international body acting on behalf of governments. In our case, the IP office at the Ministry of Justice, or you could go through ARIPO, that is the African Regional Intellectual Property Organization. And on the side of trademarks, or other marks, service marks, the same thing, you need to register. Having the mark is not sufficient. And I'll give you a very recent example between two service providers. I need not mention their names. There was a service provider using a service mark, and this service mark became very famous to all of us. And all of a sudden, we saw another service provider operating in the same line of business, using the same service mark used by its competitor. And the only thing the competitor could do was to go on television and caricature and make funny things, say funny things about the other one who is copying them. They couldn't proceed to court. Who knows why? Who can answer? Why? Anybody? Because they did not register. I said registration secures the right. So if you did not register your rights, and somebody uses the same thing, then you cannot go to court because you do not have any claims. That is in the industrial property sense. In the copyright sense, yes, in the Gambia, the law requires that you do some form of registration. But I've always argued in fora that that registration should not be a bar to the enjoyment of your copyright. Once the work is completed, it is fixed, then you enjoy automatic protection, because we are part and parcel of the international community, and the Gambia is a signatory to the Berne Convention of 1886, which provides protection without going through the formalities of registration. So in that regard, what registration would serve is that it will serve as constructive notice. I'm talking in the sense of the Gambian law. To me, it will serve as constructive notice to the general public to know that there is a copyrighted work. 2, it will enable the National Council for Arts and Culture to also have a collection of copyright works, to have a bank of copyright work data. And 3, it may serve as a piece of information provided need arises for you to go to court. But non-registration, as far as our membership to the Berne Convention, must not serve as a bar to the enjoyment of your copyright. That is just to briefly explain to us what is this when you talk about industrial property and copyright and related rights. But to add another feather to the industrial property is the fact that it is territorial. Those rights are territorial, meaning that you need to seek protection in every place that you desire, that you are desirous of having your rights protected. Say, for instance, you want protection in Zimbabwe, you need to register in Zimbabwe. You need protection in Swaziland, you have to register in Swaziland. You need protection in Gambia, you must do the same thing. You either have to register with the local office or you go through the regional route and designate those countries where you are desirous of having your rights protected. As I said, the rights we protect are monopolistic rights. And when you seek protection, you have to disclose information, which is very important here. The information you disclose to the office is that you have a patent. You need to tell us the technical information that is there for you that enabled you to come up with that invention. That information is now information for the public. But then the fact is that the information cannot be made use of by anybody until the term of protection, which is 20 years under the Paris Convention of 1883, elapses. If that period now elapses, it means that every other person skilled in the area can study that information and take your invention to the next level. And that is why sometimes people will say IP rights are cudgels with which to smash competition. Yes, that may be true, but the fact also remains that there are rights that are sine qua non for progress and development, because if you invest in research and development, as my colleague just mentioned, you want to recoup from that investment. And we know research and development can be very expensive. So if you invest in research and development, you came up with a very good product, say for instance, University of the Gambia Agriculture Department, you decided to develop some fertilizer, and all of a sudden, NARI also picks on that and becomes a competitor who have not expended any effort in that regard and went into a commercial effort. Then it means the University of the Gambia would not realize the profits that they were supposed to realize if they had sought protection for their IP rights in that regard. So the monopoly is provided for by registration. And in that regard, as I said, international routes provides protection, the local routes provide you protection, and the Office of Origin also may provide you with protection. In the copyright sense, it is automatic. In the industrial property sense, you need to register. Registration is a requirement. Now, the point I was trying to explain is in relation to the disclosure, because this is where information now is shared with the public. We know in the copyright sense, before it was very difficult for you to copy content. You needed to have a physical presence sometimes. And you needed to do a lot of effort. Much effort was required before you can copy content and make it available. Today, with the rise of the broadband internet, you can sit in the comfort of your house and copy in as much content as you want and distribute it. In many, many ways, you can distribute this content. Now, how do we protect that? This is where the question now arises. Information that you give to the IP office for protection is information that is useful for people, for persons technically skilled in the area. So we will keep it for you until at such time that the time for protection elapses, and then it becomes public knowledge for everyone else to use. But then, as I said, today the internet has made it very easy for us to copy content, especially in the copyright sense. You sit in the comfort of your house, record in as much as you can, and distribute. Make a commercial effort. that amounts for an infringement. For most time, because we do not know, we will sit and remain quiet, or you can take action. I'll make you remember a few cases, or I'll bring to your attention 2 cases. You may be aware that there was a case before the High Court involving an auto, and it was concluded, well, whether on merit or on technical grounds, the fact remains that the people who were taken to court were found liable and were, fined very heavily for what they have done. But then there was also a case that was not concluded. And this is important because we are talking about securing our rights. The law has provisions in case of infringement. And this case, which might not have gone into the public, was a case involving Be in Sport Media, and Super Sports. It was a case that had been meandering in Gambia for quite a while, and until eventually it was brought to our attention at the office, then we advised. We are almost, we are very far into the case in court, and the consequences could have been very colossal for those who were infringing the rights of Be in Sport, because they were using broadcasting signals not bound for the Gambia, and the law prohibits the use of signals not bound for the Gambia. So we need to understand that, yes, the provisions of the law are very clear in terms of what we can do with copyrighted material and what we cannot do with copyrighted materials. So the security of the right owners, of course, is guaranteed under the Copyright Act. It's also guaranteed under the Industrial Property Act. As I said, under the Industrial Property Act, you need to require registration is a requirement, otherwise you cannot have protection. To also further allay fears, because we are part of the global community, someone may ask, what about foreign nationals? As I said, we are not an island. We are part and parcel of the international community, and we are a member of the Paris Convention. We are, therefore, member to the Paris Union. And what it means is that by virtue of our presence in those 2 international legal legislations, that is the Paris Convention of 1883 and the Berne Convention of 1886, all of which are administered by the World Intellectual Property Organization, it means that we have also subscribed to the principle of national treatment, which are found in both legislations. And it simply means that we treat our nationals the same way as we will also treat foreign nationals. It's not easy to say everything at a go, but provided there are loopholes, I will appreciate when they come during the question and answer session, and I will provide answers as I possibly can. Thank you.
Okay, thank you very much, Mr. Jallo, for that wonderful deliberation. So I would just like to buttress on what he had said already and emphasized on it more because it's very essential. One of the things that he had said is registration, which is one of the key problems that we have. As from my experience working with the AG chambers and as a lawyer, Gambians with the habit of reporting already existed problems. So people don't use preventive measures. Like you will see people trading in trade names and doing business using particular trademarks. They wouldn't register. So they will only approach when there is a problem, which is difficult to administer at times. Sometimes it leads to certain losses or even great loss in their business sectors. So we always advise, and at AG Chambers, we usually, most of the time, like 99%, we give free advice. So if you have issues that you aren't sure of, and that involve law and legal issues, especially in terms of issues discussed today, and which will be discussed furthermore, you can always come, and then we will advise you happily. so that you do not get into trouble and then, approach a lawyer. Sometimes it can cost you a fortune. So having said that, I will allow Mr. Omar Jallo to talk on the other aspect of intellectual property, which is copyright. Mr. Jallo, you have the floor.
Thank you, Chair of this session, and welcome, Mr. Reiner, and members of the panelists, and distinguished ladies and gentlemen. I would like to first state that I am the only person who is not a legal practitioner or who is not a learned man, as they will always say, the learned man. But intellectual property, especially copyright, I would like to demystify that, to say that it's not only the lawyers or legal practitioners who are the administrators. I am an artist. I'm not a learned man. I am an artist, I'm a creator. So copyright can be administered and worked by creators. In fact, it's their right. You don't need to get a legal-minded or a learned man to administer copyright. So I would urge some of you who are not legally minded or who are not learned men to get into this profession and learn more about copyright, because it's about administration. Most of us at the office there, we don't know anything about the legal practitioner. Yet still forgetting about the content providers, the creators who are making those works, who are providing those contents that you will download in your, take it in your phones, in your laptops, or even the apps that you are using, the softwares that you are using. But I haven't heard anybody, how do we protect them? Do they need protection? You benefit, most of us, especially from government, we benefit from Social Security. When we grow old, or when we pension, we walk into the Social Security and work there and say, hey, I have worked for the government for 13 years. Please pay me. They pay me, I go home and enjoy that money. How about the creator who has never been employed? All his work has been based on making apps, developing programs that will go through the internet, through your phones. Do you ever remember, or do you ever think, when they grow old, when they go pension, what do they do? What do they benefit from? They don't go to Social Security and claim, hey, I was developing apps for the past 30 years for the Gambia, and now you should pay me, because they've not been paying Social Security. They cannot walk into the Social Security and claim benefits that they have not been living down there. So how do they live? Do you mean that only thing that they live in is on the benefits that they derive from the immediate gains? When you receive your salary, you derive an immediate gain right from there, and yet still Social Security is paid for you. As an artist, or as a creator, or an inventor, there is a protection in the copyright law which says they should be protected and they should be paid. I like that part of copyright. In fact, the Copyright Act of 2011 ordinance was just a framework, and it was repealed by the 2004 Act. And the 2004 Act gives 2 tiers of representation in this, which is the Copyright Office and the Collecting Society of the Gambia. The Copyright Office is actually to help in terms of fighting against piracy and working the legal framework for us to have a conducive environment so that we can also mitigate in between parties. But the Collecting Society of the Gambia is the apex body responsible in the creative industry, just as the Chamber of Commerce is in trade. That is the body that stands on behalf of the artist or anybody who is a creator. And this body, their primary role is to negotiate on your behalf, and get your mandates so that they go out there and receive royalties on your behalf and they distribute it evenly to the right holders. But these two tiers, they operate side in side. And most of the time, the Copyright Office for Protection of Copyright Works, they also include literary works, that is creative, artistic, choreographic, and folkloric works. Of course, programs carrying signals like television and some of the programs or satellite programs that you will watch in your homes. How many of you do pay for the satellites that you are using in your houses? How many of you pay for the music that you download every other day in your laptops, in your computers, in your phones? Forgetting that there is a creator who has worked and spent money on this, and he is not reaping anything from it. In fact, most of the time, it's the GSM companies who will benefit, because they will tell you, if you download that sound, you'll pay $1 or $2 or $3. They are the ones that are benefiting. But how does that even reach to the artist who has sat down at the middle of the night to think about that lyrics, to think about the scores that will come along with that music, and go to the studio, pay for the composer, and does the work, then publish it, then it's right into the gadget of the GSM operators, and now they are selling it to you when nothing comes down to the creator himself. And in terms of computer software programming too, it's rather unfortunate. I am not sure if our attention or the Copyright Office have to really reorient ourselves properly again. Because I am very surprised, as I am talking, for 15 years we've been administering this law, and I do not have a single registration as a software or application. It means that no Gambian is creating any application in the Gambia. No application has been made in the Gambia. Nobody created an application or a software in the Gambia. Oh my God. That seems really serious. When I talk about copyright, it's not about the creative aspect only, but this computer software, the computer programs that you make, these are all related rights programs, because they are classical materials that actually comes from creations of works, and they are user-friendly. And you need to pay for this, but most of the people don't even come forward, even whereas they have developed applications for their own departments, they don't come forward to register it. So registrations for software applications at the Copyright Office in the Gambia is 0. For programs in the Gambia is 0. Applications in the Gambia is 0. Meaning that no Gambian is, I think, anyway, some of the regulations that we have in place, which the minister have signed, includes the work registration regulation of 2010 and the copyright regulation of 2015. And these regulations actually help to provide the latter, to provide for the national repertoire, so that we have a repertoire which is to know the creations of the Gambia, what we have created and what we have not. And the other is to give provisions for the general administration of copyright, enforcement mechanisms, and collection and distribution of royalties. These are the 3 pillars which are very necessary in terms of copyright implementation. First, the legislation must be in place, there must be a management, and there must be an enforcement. If there is no enforcement, there is no use. If there is no legislation, there is no management. So we have to deal these 3 pillars, they are very fundamental. And knowing that very well, we know there is crimes that are attributed to copyright infringement. When people infringe on your rights, there are 3 ways that you can address this. One, you can take the alternative dispute resolution which